Hey out there, legal warriors. In this video, I'm going to cover how to win your protection order case in Washington State. Some people call it restraining orders. The legal term in Washington is protection order. Stay tuned if you're interested in this area of the law. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes and handling protection orders for more than 25 years all throughout Washington State. And I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people get to see it. More people get to get the help they need. Now I'm just going to jump right into it. In Washington State, there's a law called protection orders, and it's under RCW 7.105. And if you've ever been served with a protection order, you're going to know it's a pretty bad law. It's really against respondents. And what do I mean by a protection order? What is that? Is that a crime? No, being served with a protection order is not being accused of a crime, although sometimes they'll talk about crimes in these things. A protection order is for one person who's called the petitioner asks the court to restrain another person called the respondent. And when the petitioner files that initial request, it's called an ex parte request, which is a fancy term for meaning one-sided without notice to the respondent. And so the respondent generally gets served with a temporary protection order that the court looked at, the request from the petitioner, without any notice to the respondent. And therefore you get this order, it's handed to you, it says you might have to leave your house, you can't have contact with someone, maybe the other person gets your car, maybe the other person gets your kids, maybe it's your neighbor. It's pretty much a nightmare. And then it's just all this paperwork. It might be like 25 pages with a temporary order and the petition, and maybe there's an order to surrender weapons, and your head just spins. And then it's going to have a return date when you're supposed to go to court to tell your side of the story, like they even care about your side of the story, right? They already issued an order without even caring about your side of the story. In fact, the law says you don't get to tell your side of the story when they go in and ask for their ex parte order. So I'm making this video right now about how to win one of these orders if you're on the respondent side. How do you win on the petitioner side? A lot easier to do because the law benefits them. So this law focuses on respondents. What don't you do if you want to win? You don't just show up in the court date and expect to raise your hand and testify about what happened. Why don't you do that? Because these court calendars where these orders are heard are congested, right? It's different in each area, but in King County, Snohomish County, Pierce County, Skagit County, I've been to all the counties, Island County, you name it, I've been there on these orders. You're not the only one on the calendar. Sometimes they might have 10 or 15 orders on a calendar that might last for only 2 or 3 hours. And so for the most part, always check with a local lawyer to make sure that the court you're going to go to is doing it like I'm suggesting they're doing it. But for the most part, they're not going to take any type of extensive live testimony from the respondent. And think about it, it wouldn't be very effective anyway because you've got this commissioner or this judge sitting there who's already read all the stuff the petitioner wrote about you, all the bad stuff that got the temporary order issued against you. They're coming into this case already thinking that you're, a really bad person, and you're not going to be able to talk your way out of that in a courtroom full of 25 people where you got 5 or 10 minutes. So what the court wants you to do is the court wants you to file something in writing in response to what the petitioner claimed against you. And oftentimes you can't get that done by the first court date. So to win your protection order, the first thing you need to do is you need to get sufficient time to be able to do a good job. So most of the time a respondent is going to go into court, they're going to say, hey, judge, I need a continuance. I need some more time either to file a response or to get an attorney to help me file a response. And more often than not, the commissioner's like, yep, you can have the time. You can have it because I've already got all these other things on the calendar I don't want to deal with today. I hate my life because I'm sitting here on this protection order calendar. And why am I the one stuck enforcing this bad law that the legislature wrote? So you get that sufficient time so then you can file a response. Because the most you're ever going to have is 2 weeks anyway, right? They set these hearings out 2 weeks after the temporary is issued. Who knows when you get served? And legally speaking, you're entitled to a continuance if you're not served 5 court dates ahead of time. which is typically 7 calendar days, but if there's a holiday in there, it might be 8 calendar days, right? So you're entitled to a continuance if you're not served in time, but usually you're going to get a discretionary continuance granted, but make sure you talk to some local attorney if you can to find out what is common in the court that you're going to, because again, every court is a little different. It's a little bit harder to get a continuance in certain district courts in Snohomish County, and I'm going to keep my mouth shut about where the problems are there. So when you are thinking about filing this response, like, what am I supposed to do, Lance? What am I supposed to write? Some of us aren't good with word processing. Some of us don't know how to do this. Well, the fact is, it is mainly a written type decision situation. You have to take a look at what was written in the petition, and then you have to sort of look at the law to see what the petitioner needs to prove at the hearing. And the law is under RCW 7.105. And if you look at the stuff you're served with, there's going to be definitions of domestic violence for a domestic violence order, for unlawful harassment for an unlawful harassment order, of assault for one of those type of orders. And you can take a look at what the petitioner needs to prove, and then you look at what they've written for claims. And sometimes they're going to include police reports, sometimes they're going to include text messages, photos, stuff like that. And this is really hard. You need to answer each and every one of those claims, and you have to do it in a way that protects yourself. You also, have a right against it to not, incriminate yourself. So you have to be careful if they're accusing you of punching or hitting them. You don't want to say, yeah, I only kicked them, because that's admitting to a crime. But you need to write a response that tells your side of the story, and that also refutes their side of the story, and makes it so it's clear to the court that the petitioner hasn't provided enough evidence, which just means their claims, to support that it's more likely than not that you did something that entitles them to an order. You did domestic violence in a domestic violence case, you did harassment in a harassment case, et cetera, et cetera. If you have a domestic violence order against you, remember, it's not the criminal definition of domestic violence, it's the civil definition. If you read that civil definition, which includes coercive control, subjective fear, it's basically garlic breath. If you got garlic breath and they don't like garlic, well, they have enough of a claim to get an order against you, and therefore you have to be really persuasive in your writing and show that, hey, you're the one suffering, not the petitioner. So the best thing you can do is to get yourself an attorney, and attorneys are hard to find in this area. We do excellent work in this area, but we only do a very limited number at once because it's so hard. But you need to find yourself an attorney who can help, hopefully, you draft a response. If you can't, you're going to have to do it yourself. So when you are done with your response, what do? Do you just take it with you to court and wave it around? No. The next step is you need to file it with the court. You need to follow the court instructions for how to file the response. It's going to need to be properly captioned. What's that mean? Do I mean closed captions like on TV? No, I mean it needs to have the right, it has to have the court name, Snohomish County Superior Court. It has to have the petitioner's name, Mr. Smith, petitioner, Mrs. Smith, respondent in this hypothetical. It's got to have the case number. And so usually you're going to be able to get some type of respondent packet from the court that helps you explain how to do these things. They might have a few printed out examples that you can photocopy. You can go to the Washington Court's website sometimes and download forms in PDF or Word format to try to do these things. But you need to follow the court's instructions for filing the response, and then you need to follow the court's instructions for serving the response on the petitioner. And some courts are okay with you emailing the petitioner directly. Some courts find that to be a violation of the law. So you need to take a look at the court. The very conservative courts will say, hey, have somebody else who's not a party to the matter, 18 years of age or older, serve the petitioner with your response, because just like you got served with what's in the petition for the final hearing, the petitioner's entitled to see what you filed with the court too. So it's a lot to talk about, Lance. How the heck am I supposed to win this? So let's say you get through all these steps. You've got your response, and it's as good as you can do, and it's been served right, and now you get to the court date. How is it that you win? Well, number one is you pay attention, right? You're probably not going to be the first hearing to go. And a nice practice pointer is if you're going to have to go to either a King County Superior Court or a Snohomish County Superior Court protection order matter, you can show up on another day and watch other hearings, right? King County protection orders are typically at 8:30 in the morning. They start at 9. And Snohomish County Superior Court protection orders are at 9 a.m. And for each of those two major counties, they're every single day. So there's lots of opportunities to watch and listen and learn about how these commissioners and how these judges rule. But basically, the main thing is that realize that this commissioner or this judge is going to have already read everything in the file. They're going to have read the petition, going to have read your response, they're going to have read the reply of the petitioner. So they're going to have some idea of what they want to do when they come out. So basically, it pays to be the adult in the room during your conversation or your argument. If the other side is claiming that you have a temper and you do bad things and violent things, you don't want to show up in front of the court with the temper and being really mad, because the court's going to go, yep, I believe that, here's the order, right? Same time, let's say the other side you're claiming is more hysterical. You're claiming the petitioner is paranoid and the petitioner likes to see things that aren't really there. Well, if you're lucky, the petitioner is going to be the one running his or her mouth and seeming ridiculous. And now if you are the adult in the room, it's like, I now believe everything I just read from the respondent that said stuff like that. And so what happens in court can actually change the outcome. Now, more often than not, the court's going to have their mind made up when they come in, but it depends. Each commissioner is different, and if you have an experienced attorney, they're going to know, hopefully, how to behave based upon past experience with certain commissioners, because they're just people with their own ideas, with their own interpretation of the law, those type of things. But for the most part, what you don't want to do is lecture the court about your general good character or stuff like that. As a respondent, you want to focus on evidence. And when I say evidence, that doesn't mean physical proof, photos of injuries. It just means you use words like, hey, in this case, the evidence is insufficient to show that this happened. You don't say stuff like the petitioner hasn't proved his case. You want the court to not reject the petitioner. That's tough to do. The commissioner or the judge doesn't want to be put in the emotional position that I'm going to reject the human, that's the petitioner. You want them to reject the evidence of the petitioner. And that is the sort of the psychological change that you have to think about when you're making an argument as a respondent in the protection order case. When you're the pro se, the unrepresented person, how you behave can actually make a difference. Sometimes in our cases, even though I don't have to have a client testify, and sometimes it's a good idea not to, if I've got a really well-presented client who's calm and articulate, I want that client to say something to the judge so the judge can now make their own judgment about their veracity and their tone and see how it matches with what we already wrote. And so sometimes attorneys make a mistake. They don't have their client say anything. And when the client doesn't say anything, now they're just stuck listening to the attorney. And, they've heard us attorneys before, right? How we talk is going to sound pretty similar to a very, well-presentable client versus a not so well-presentable client. So, if my client isn't going to sound very good, well, I'm not going to let them talk, obviously. So, what happens then? How do you win that hearing? You get that good response filed. You make sure you follow the rules so it can actually be served properly. You protect yourself by not admitting to crimes and things in there, and you focus the response on what is actually relevant from what they have to show, and you have to read the law for that. And then you're the adult in the room. You come off more credible, and guess what? You end up winning. Cases can be won that are unwinnable if all of the rest of this lines up. It happens every day because these cases, while they are based upon the law, it's a human making the decision, and the human, as time goes on, they're tired. They're tired of seeing so many of these cases. So many of them are misused. So many of them are total BS. Hopefully I can get away with that, YouTube. If you can, not expect the court to necessarily believe you, just expect the court to say, hey, the evidence is insufficient to prove what they need to prove. Therefore, while I'm mad at everybody, I'm not giving you your order, petitioner. That's how I want it to end up. So I hope you found this useful. If so, please like and please subscribe. More people get to see it. More people get the help they need to get a protection order out here in Washington State. You can reach out to our firm. If we get on board, we'll listen to what happened, we'll identify a way forward, and we'll be there for you. Thank you.